to impartially review the president's tax returns?
Congressman Delmeni, I can't comment on the impartiality. I think it is suggestive that there was a problem, whether it's simply incompetence or partiality, I don't know. In fact, what happened in that instance is after the Joint Committee did its determination, the IRS went back and actually audited again and essentially confirmed the Joint Committee's determination and reversed its own first determination. So there was obviously a problem with the first audit, but I can't tell you whether it was out of a feeling of partiality or whether there was undue influence or simply some people weren't doing the job they're supposed to be doing.
But by allowing others to review those documents, we were able to find out that they were not actually correct.
Well, I think it certainly raises an issue that might be worthy of the committee's concern, which is that if a very high-ranking official is being audited, whether it's the president or the Treasury Secretary or somebody of that nature who has a supervisory role over the auditors, it seems to me that it might be a good policy for the committee to double-check that type of situation.
Thank you. Dr. Thorndike, given the current pressures on the IRS and what happened with Nixon, should the IRS requirement to audit tax returns of presidents and vice presidents be codified? Your microphone.
As with the disclosure requirements, I think that these would be better off codified than handled through the internal policies of the IRS. I just wanted to add that during that Nixon episode, there was very real debate and real concern about the sufficiency of an IRS audit, and there were calls for outside auditors, or what that even meant. They weren't sure, and eventually their answer was the Joint Committee could be that outside auditor, but there was real concern that the IRS had missed this the first time through. Part of the explanation is that they actually had a change of commissioner in the middle of it, and the new commissioner, I think, took a much more vigorous approach to this. But I think it's quite reasonable for people now to worry, based on the actual experience in the Nixon administration, that the IRS may not be able to really vigorously enforce the law relative to the president. I think they try very hard. I don't mean to slander the IRS. I see this as a structural problem, not as a criticism of the IRS itself.
Thank you. The committee, Professor Yen, I'll go back to you. The committee must make a written request to receive a return. Is there any limitation on what returns or return information can be requested?
No, there is no limitation. The committee can ask for anything it wants. I think good practice would suggest that the committee be somewhat targeted in your request simply because it would take a lot of time if the requests were very broad.
Thank you. Thanks to all of you, and I yield back, Mr. Chairman.
The chair now recognizes for 5 minutes, Ms. Sanchez.
Thank you, Mr. Chairman, and to our witnesses, your testimony has been informative as we work through this very important issue, so I want to thank you first and foremost for being with us. I think it's long past time for this committee to do its constitutional duty and operate as a co-equal branch of government, and I can say that I've been proud to be part of the committee and House floor efforts to properly exercise our authority, because as members of Congress, we take an oath to uphold and defend the Constitution. And when we swear that oath, we recognize our responsibility and our duty to uphold the integrity of this institution. Holding the executive branch accountable is a bare minimum step, I think, in fulfilling that constitutional duty. To me, here the facts are pretty simple. The American people deserve a full picture of potential conflicts of interest for those who have the privilege of holding the highest elected offices in our country, or those who aspire to hold them. Transparency is a pretty good thing. The American people have the right to know the financial interests of those that are crafting policy that affect them, and hearings like this and passage of legislation like H.R. 1 will move our country forward, not backward, in the issue of transparency. Since this administration began, we've seen countless examples of why this information should have been disclosed, like in every other presidential candidate in modern history has done before for the last several decades. From tax reform to dealing with foreign entities and individuals, the American people deserve to know exactly whether their executive stands to personally benefit or be unduly influenced. The personal business endeavors of the leader of the free world should be held to very high standards indeed. Dr. Thorndike, you previously mentioned that you would like to see the release of tax returns codified. Are you worried that this tradition, because it is just a tradition right now, is being eroded?
I am concerned that it may, in fact, be completely broken. And I think that we can't count on traditions. If we believe that this sort of transparency is important, and I do, then we can't really depend on a tradition to get the job done. And I mean, just as an example of that, let's think about maybe the most hallowed tradition in American politics, which was the two-term presidency, which was revered by everyone until it wasn't. And when Franklin Roosevelt broke that tradition, Congress responded by actually making it a law, or the nation responded by making it a part of the Constitution. I think if things are important enough, and I believe that transparency is one of those things, we should in fact require them legally rather than just hectoring people to try to get them to do what we want them to do.
I happen to agree. And Mr. Thorndike, if presidential hopefuls' tax returns are released, they are redacted so that sensitive information like Social Security numbers and other important information is not released to the public. Is that correct?
Yes, the Social Security numbers have been blacked out for a long time. They were not originally. I think this was before the era of rampant identity theft, but they have been now. They are routinely. I mean, presidents have been blacking them out for 40 years.
Thank you. Professor Yin, you just heard Mr. Keyes' testimony. Do you have any comments with respect to his testimony?
Yes, I do. I think a few words of history would help to clarify the misunderstanding that Mr. Keyes seems to have on this point. In 1924, when this when Congress began thinking about the law that is before us today, Secretary Mellon vigorously objected and was concerned specifically about the potential disclosure of the tax return information to the public. And he urged over on the Senate side in a Senate hearing 2 changes. One is, he said, any committee that receives the information must do it in closed session. And second, if any of the information goes to the full House or full Senate, it also must be done out of public eye with nothing included in the congressional record. Congress in 1924 agreed with the first step, which is why if you were to seek information today, you would need to do it in closed session. But it specifically rejected the second step. And the reason was that it was inconsistent with the congressional goal in 1924, which was, as a co-equal branch of government, it wanted to give itself the exact same rights as the president had. The president at the time had the ability to obtain and disclose anybody's tax returns. Fast forward to 50 years later, the same issue arose in 1976, and what Congress did is they took away the ability of non-tax committees to make disclosures, but they did not take away the tax committee right. Just if I could add one final point, which is that some of you may be wondering, well, why does the statute, as Mr. Keyes suggests, the statute only says you may submit and not make a public disclosure? And although I don't find anything specific in the historical record on that point, I think there's a very easy explanation. And it goes to the fact that in the mid-1920s, party affiliation was not nearly as important as it is today. So there were a lot of progressive Republicans who tended to vote with Democrats on issues like this one, issues of disclosure, investigations, and so forth. Meanwhile, Congress was controlled by the old guard Republicans. So Congress, the leaders of Congress did not want a single committee to make the determination of whether something is disclosed to the public or not, because they didn't know what the specific makeup of that committee might be. It may have a number of progressive Republicans on it who would vote in favor of disclosure. They wanted the full House or the full Senate to make that determination.
Thank you,
and that's why they develop this procedure where all the committee can do can be to submit
Professor
to the
Yin.
House and Senate.
Thank you.
Thank you. I'm sorry my time has expired, but Mr. Chairman, I would ask unanimous consent to submit a letter from the former acting director of the Office of Government Ethics, Dan Fox, in
Without
support of
objection.
Title 10 of H.R. 1.
Thank you very much.
Thank you, Mr. Chairman.
The chair now recognized for 5 minutes, Mr. LaHood.
Thank you, Mr. Chairman. I want to thank the witnesses for your testimony here today. In a prior career for me, I was honored to serve as a federal prosecutor and a state prosecutor, appeared before many grand juries. Section 6103 under the statute allows the federal grand jury to subpoena tax records. And I guess as I look at this issue, obviously it's not a surprise to anybody. We have an ongoing independent counsel investigation, a grand jury that's been impaneled for over 18 months. Out of that grand jury investigation have been a number of indictments related to tax fraud. Clearly, under this grand jury of the independent counsel, as with others over the last 40 years, there's the authority broad to go after tax records, look at criminal violations, look at civil violations, and I have no doubt that's ongoing today. And I guess as I look at this, I'm a little perplexed and confused on why we would give the authority or why we would have the chairman of the Ways and Means Committee ask the Department of Treasury for the president's tax records. And as I look at the last 40 years of the independent counsel investigation statute, I've been trying to figure out whether there's been another example of this, and I have not seen any, and so that causes me some real concern. And I guess, Professor Yin, you're the historian. Can you provide the committee with an example of where the chairman of the Ways and Means Committee has asked the executive branch for their taxes when there's an ongoing Department of Justice independent counsel investigation?
Congressman LaHood, I can't think of an example off the top of my head, but I think it's important to understand.
Reclaiming my time, would it surprise you to learn that one does not exist?
Well, again, I can't think of one off the top of my head. The authority itself has been rarely invoked, so it's really just a handful of situations.
Thank you. Dr. Thorndike, can you provide the committee with an example of where the chairman of the Ways and Means Committee has asked for the president's tax records when there's an ongoing independent counsel Department of Justice investigation?
No.
Do you have any evidence to support that that's been done in the past?
I'm not aware of anyone having requested the president's tax returns in the past. Am I correct about that?
While there's an ongoing independent counsel investigation?
Yeah, but has there been any, have they ever requested one?
Well, again, would it surprise you to learn that that, in fact, has not happened?
No.
Okay. Mr. Rosenthal, same question to you. Can you provide the committee with an example of when that's occurred?
I'm unaware of the historical record on this point.
Thank you. Mr. Bookbinder?
I guess I would say that I believe that presidents have voluntarily disclosed their tax returns while under independent counsel investigation. So I'm not sure the issue would have come up.
So let me ask you this. So on that point, Whitewater was an independent counsel investigation, correct? During that time, do you know if the Ways and Means chairman asked for the president's tax records?
I don't know, but I believe the president voluntarily disclosed them.
So President Clinton voluntarily disclosed them? Is that your testimony today?
You know, I'd really defer to the historians, but my sense is that for 40 years, presidents routinely have voluntarily disclosed tax records.
Would you be surprised to learn that the chairman of the Ways and Means Committee has never asked for that with an ongoing independent counsel investigation?
I don't have any reason to think differently than the historians on this panel.
Well, thank you for that. I guess going back to my original thoughts on this, as I look at it, we've had approximately 30 independent investigations by DOJ. And the broad authority that they have, like this independent counsel has, is real. And to think that this committee would want to be engaged with asking the Department of Treasury for the president's tax records, again, is confusing to me. It's never been done. And as I look at what this committee should be based on, this seems to me like a waste of time, of resources, and energy here. And as we talked, Professor Yin, you did a great job talking about the legitimate purpose for why this should be used. And I look at the legitimate purpose and the legal purpose on this, and I do not see it. And I go back to what a number of my colleagues said on weaponizing the tax code and setting a precedent that's never been done. And we should all be concerned about that. Thank you. I yield back.
Now recognized for 5 minutes, Mr. Swansea.
Thank you, Mr. Chairman. Thank you so much for conducting this hearing, and thank you to the witnesses for your time and for your expert opinions. Dr. Thorndike, I was going to ask this question, but just in response to my friend Mr. LaHood's questions, did President Clinton voluntarily disclose his tax returns?
Yes, every year that he was in office and while running.
So there would have been no need for for the chairman of Ways and Means to ask for his tax returns, despite the fact there was an investigation going on, because they were disclosed publicly.
Yeah, I mean, more generally, there would have been no need to request any president's tax returns in the last 40 years because they've all been a matter of public record.
Okay, I really want to focus on H.R. 1 and the conflict of interest questions. That's the thing that I'm most concerned about. We have a duty here to try and protect the American people and to make sure that we're doing our jobs. This can't be a partisan thing. It's got to be something we're doing to follow our duties under the Constitution to make sure that the public has the information that they need. Mr. Thorndike, you told me earlier that you were, your doctorate's in history of 20th century politics in America.
Yes.
So what would be examples of conflicts of interest that someone might have had throughout history, or maybe something that was uncovered in some of these disclosures that have taken place? Or if you can't think of a specific instance of something that's been discovered, what would you speculate could be a potential type of conflict? Give us like real type of examples.
Well, I mean, I'm not aware of there ever being any discovery of financial conflicts of interest involving an American president. They may have been there and not revealed. Most presidents have put their assets in blind trust, so it's not clear whether or not the president would even be aware of what those conflicts might be. I mean, you know, one could imagine that any piece of legislation, if it is going to change the tax code in a way that benefits the president, might be of relevance to the president. Is that a conflict of interest? I mean, that's hard to know.
Well, it's really the appearance of a conflict of interest is what we're most concerned about, isn't it?
Yes, I mean, and
so for example, President Johnson had a lot of business interests, for example. Would there be potential conflicts of interest based upon your knowledge of his history?
I would imagine so. I mean, this was before presidents were releasing their tax returns, so we wouldn't know exactly what they are.
So, Mr. Bookbinder, you talked about different types of conflict of interest that could potentially exist. What are the ones that you're concerned about most?
Well, I would just first of all say that part of the reason why it's hard to find a historical example is because no president has retained a massive global business interest the way that President Trump has previously. So we're really in uncharted territory here. But I would be very interested in the most basic conflicts kinds of questions in terms of how would the president's own tax interests be affected by the changes to the tax law he's made? And then we've also seen that this president has had extensive business dealings with foreign interests. That's something we could learn more about potentially from tax returns. That could be incredibly important.
Well, how would we find that in a tax return if it's his individual tax returns? Would the individual tax returns be sufficient, or would you need to see his business tax returns as well?
I mean, of course, it's hard to know exactly what would be in his tax returns. It may well be that if he's receiving foreign income that he'd be disclosing that. But certainly with the kinds of very complex business interests with literally over 500 different interrelated companies that this president has, it points out the importance of getting those business tax returns, which are going to give a lot more, potentially a lot more information about where the money's coming from and what the interests are.
It doesn't have to be specific to President Trump, but could you give an example of a foreign interest in a business that would be a conflict for a chief executive?
I mean, certainly, really almost, for instance, if there were, if a president had an LLC or some other kind of company which had a partner that was a foreign company, potentially even
so a partner. So an investor could be someone from a foreign country that you could have undue influence.
Exactly, and especially if it's
what would be a type of business that a president could have an interest in, that if money was brought in through that business would potentially impact the president's decision or vice president?
Well, for instance, a lot of foreign governments have very extensive funds that invest in businesses. And so if there was a sovereign fund that was putting money into, say, a construction project, if there was a Saudi fund or a UAE fund, that could affect the way the president looks at any decision that involves that country, conceivably.
Okay, my time's about to expire. I yield back, Mr. Chairman. Thank you.
Well, thank you very much. Now the chair recognizes for 5 minutes, Ms. Shu.
Mr. Yin, I understand that the chair of Ways and Means has the authority to ask for the president's tax returns. Then Ways and Means can vote to submit it to the House, and then the House can vote to make the returns public. Mr. Keyes made a startling assertion when he said that if the committee votes to release any tax return information to the full House, it would risk a criminal violation. In fact, he talked about a felony that would be worth 5 years in prison. Based on your expertise, do you agree with this interpretation? And I would like to also ask, do we indeed have the legal authority to obtain these tax returns and to submit it to the House to make it public? And why is it that we've had this authority for 100 years?
Thank you, Congresswoman Chu. I don't agree with his view. I think that the historical record is very clear as to what the intention of Congress was in creating this authority for the tax committees, and it was to allow the potential of a public disclosure. I think that to think otherwise right now would require us to believe that Congress forfeited its ability to exercise its informing function with respect to tax return information. That is, nobody could ever inform the public about any matter of importance to the government if it involved the disclosure of tax return information without suffering a criminal penalty. I don't believe that's the case. That would be an inconceivable outcome in my view. And I would further add that in the few instances where this authority has been used, in every single instance, there has been a public disclosure at the end of that exercise of the authority. And I just commend to you the floor statement of former Ways and Means Chairman Wilbur Mills in 1974, when he submitted the Nixon report to the House, and he explained in just a few paragraphs exactly his understanding of what he was doing and why he was doing it. And it is exactly consistent with the idea that he was doing it so that the report could become public.
Mr. Bookbinder, some opponents of requiring the disclosure of presidential tax returns, as written in H.R. 1, argue that candidates are already required to file a financial disclosure form, or OGE Form 287E. Can you explain the primary differences between the information found on the disclosure form and the information found on a tax return, and why it would be critical, in fact, to have a tax return above the financial disclosure?
Sure. There are a number of differences. One of the most stark ones is that for instance, for income on a financial disclosure, any income over $5 million, there's simply a box that says over $5 million. So somebody could be making $6 million or $600 million, and we wouldn't know the difference looking at their financial disclosure form. Obviously, a tax return is going to be much more precise. There are a lot of areas from loans to investment partners where we're likely to get very different information from the tax returns than we get from the personal financial disclosure form.
How about the issue of whether the candidate has paid taxes or has avoided taxes?
Absolutely. I mean, that's the personal financial disclosures are not going to provide any information about what taxes somebody paid. They're not going to give any information about charitable giving. And those are things that are potentially very important for the American public in evaluating a candidate and evaluating a president.
And Mr. Rosenthal, you said you discussed when it would be appropriate to submit a request under Section 6103, for instance, when there has been a refusal by the office holder to divest financial interests in a large empire or a refusal to transfer their interests in a blind trust. Why is it important for Congress to obtain the office holder's tax returns and other tax information?
Well, in my written testimony, I described the unusual circumstances in which the committee might yet seek information from tax returns. one of which being if the president has not divested his financial interest in a sprawling business or transferred a blind trust. In that circumstance, the possibility of the president having income from many different sources is pretty likely. And so to see those partnership returns and the business returns could be pretty important. I'd point out, as Congressman Suozzi was asking the other witness here about partnership returns, I could tell you line 16 of the partnership return asks, does the partnership have any foreign partners? Line 20 asks of a partnership return, enter the number of partners that are foreign governments. And so when there's a sprawling global economic empire that's comprised of LLCs and partnerships around the world, there are just a lot of questions to be asked. The 1040 is merely the collector of composite information without disclosing the kinds of detail you might like to have.
Thank you.
Very good question. Saves me time.
Mr. Chairman, let the record reflect that my name is Swazi, not Swoozy.
I apologize.
I yield back.
Thank you. The chair now recognizes for 5 minutes Dr. Wintrow.
Thank you, Mr. Chairman. I appreciate that. Let me just start with you, Ms. Keys. What is the purpose of the IRS?
To collect the revenue to fund the federal government.
And what is the purpose of an audit conducted by the IRS?
To hopefully make sure that people, when they are voluntarily complying or actually are complying with the statutes, which are in some cases quite complex, but that's the purpose of audits.
And the president and vice president get audited every year?
Correct.
According to law now. Okay, so Mr. Pascrell, you said something before that really hit home. You said no one is above the law, and I agree with you 100%. Is it the law that the president or vice president bring forward their tax returns to the American people?
Is it the law that what?
Is it a law that the president or vice president bring their tax returns forward to the American people?
Well, as I think we've confirmed.
We see a testimony on that.
Yeah,
that is not the law.
That is correct.
And no one is above the law. But at the same time, no one should be forced to violate a law that maintains their privacy. You know, as a doctor, I think about what we go through to make sure we understand HIPAA and the privacy of our patients and how important that is. And it's there for a reason. It's there for a reason for patients to be protected on their private information and especially about their health care or other personal information. And why is that? And in part because people can take something from your health record and possibly use it for nefarious means or for political purposes, if they so choose. That's the purpose of that, whether it's an innocent part of your health care record or not. And so I kind of look at this the same way, but I also want to bring up, maybe any of you can tell me, and I know in the past, some presidents have put forth their health record, given the results of their entire physical. Is that true? Can anyone attest to that? I know you're mostly tax experts, but is that true? And some have not.
Yeah.
And that should be their choice. That should be their privacy. We have the checks and balances in place. We have the audits in place. But people, every American, deserves their privacy. And I compare the two. And let's take an example. And I was not around to necessarily know, but America did not know that President Roosevelt could not stand. And my guess is maybe he wanted to keep that private, so it wasn't used against him for nefarious purposes. And I think the privacy of American citizens at every level, whether it's their health care, their tax returns, there are the checks and balances there, in place for the president and vice president. And they have their rights, each and every one of us. With that, I would like to yield the balance of my time to Mr. Kelly.
Thank you, Doctor. Just while you're all there, and I'm trying to understand this, is there anybody that doubts that the president or the vice president's tax returns are not being audited by the IRS? Doctor Thorndike?
I don't doubt that they're being audited.
Professor Yin?
I really don't have any knowledge on that.
Well, yes, but you do. You're the historian. Are you telling me that you don't know that the president and the vice president's taxes are not being audited?
I know what is in the IRM, but I don't know whether, in fact, that is being carried out. I have no knowledge of that.
Okay. Mr. Rosenthal.
Like Professor Yin, I've read the Internal Revenue Manual, which calls for...
So the fact that we all know that they get audited, the fact that you weren't there to see them audit makes you wonder if it actually is being done?
Whether the president is being audited or not is tax return information and cannot be disclosed. And so the IRS will not...
Wait, not until we had this meeting tonight.
Not until a law were passed.
Okay, I get it. Mr. Bookbinder.
No, the same. And we certainly don't know, what manner of audit was done, assuming it was done.
Mr. Keyes.
I think it's highly unlikely that the IRS is not auditing the president and vice president, given what their own Internal Revenue Manual says. I find that inconceivable.
Yes, I think we all know that, especially if I was an historian that studied this, I'd have a pretty good idea what was taking place. So the only difference tonight is we're talking about the ability to make this president, this duly elected president's tax returns public. Okay, thank you. I'll yield back.
The chair now is pleased to recognize for 5 minutes Ms. Moore.
Thank you so much, Mr. Chairman, and I am, again, so pleased to be a member of this subcommittee and appreciate the witnesses for their patience today. I just came off of the Financial Services Committee on this body, and one of the things that we were looking at was the unusual lending pattern of Deutsche Bank to the President of the United States. Deutsche Bank had a subsidiary called VTB. I can't say the Russian name, so VTB. At some point, I'm just giving you background for my question. Donald Trump had borrowed $600 million and owed another $300 million, and they had called for a $40 million payment, and he said that as a result of an act of God, the financial meltdown in 2007-8, that he shouldn't have to pay it back. He was in court in New York, didn't want to pay Deutsche Bank back. Suddenly, he left the commercial real estate division of Deutsche Bank and went to the private wealth fund, VTB Bank, a bank that certainly had many Russian oligarchs who invested in that. And suddenly, his debt was paid off, and they offered him an additional $25 million. VTB Bank also is associated with this spy that was just the sanctions removed and so on and so forth. So other banks couldn't believe it. They said, "Are you effing kidding?" When Donald Trump was given this loan by Deutsche Bank. So we have a letter here from our distinguished ranking member saying, if there are valid concerns with financial disclosures, then let's come together to legislate a thoughtful solution to require additional disclosures. And this has been quoted a lot by members here. And so I'm wondering, he goes on to say that we ought to improve our ethics laws. Are there any ethics laws or any audits that will help us get to this unusual lending activity under Deutsche Bank that any of you on the panel can think of? Dr. Thorndike, Dr. Yin, Mr. Bookbinder. If we want to look at the business transactions, the line, did you say line 40 on the 1040, that is going to give us the information that we need regarding these business partnerships, relationships, and loans. Yes, sir.
Just a quick comment. I think that tax return information may provide useful leads for additional inquiries along the lines that you're describing. I'm not suggesting that the tax return information in and of itself would find some smoking gun that would satisfy your inquiry, but there may well be useful leads that you could pick up from the tax return information that with additional inquiries.
Do you think IRS audits would give us that lead? Or voluntary disclosures of just the front page of the 1040 versus the attachments?
No, I'm sorry, Congresswoman Moore. I'm talking about if the committee were to seek information, they would then have whatever return information that they sought. And from that information, that there may well be helpful leads along the lines of your inquiry.
Any of you, Mr. Bookbinder, the distinguished ranking member said that we ought to strengthen our ethic laws. What ethic laws is he referring to that we could strengthen in order to clear up this mystery about Deutsche Bank's relationship with Trump and the Trump organizations? By the way, Trump Tower was supposed to be built by VTB, the subsidiary of Deutsche Bank. Can you just tell us what ethic laws we could strengthen that would give us this information versus these tax returns?
Well, I do certainly think there is room to make the financial disclosure forms more rigorous than they currently are. I also think, especially with a president and a vice president where conflicts of interest are so important, you really need all the information you can get, and tax returns are going to provide more information on this kind of question than probably you would ever be able to get in a financial disclosure form that all senior government officials have to fill out.
And just reclaiming my last 10 seconds, I just would appeal to my colleagues to not accuse us of lazy legislating to ask for these tax returns when we have such a conflicted president. And with that, I yield back.
The chair now recognizes for 5 minutes, Mr. Ball.
Thank you, Mr. Chairman and Mr. Ranking Member. And I thank the witnesses. Under the Constitution and our system of checks and balances, Congress has not just the right, but the responsibility to oversee whether our laws are faithfully executed by the executive branch. In accordance with this duty, almost a century ago, Congress explicitly enumerated this committee's right to review any return or return information in the aftermath of 2 crises of public trust, 2 scandals, incidentally, which have remarkable parallels to the present day and this president. One was the Teapot Dome scandal, where senior officials in the Harding administration granted public oil field leases in exchange for bribes. And the other involved, as was previously referenced, Treasury Secretary Andrew Mellon, who continued to own many business interests while serving in government. Sounds familiar. Some believe the Bureau of Internal Revenue, as it was then called, gave him and his businesses preferential treatment. So again, the parallels between the scandals of a century ago that gave birth to this 1924 law and the present day are really remarkable. For example, President Trump maintains a sprawling business empire which he refuses to transfer to a blind trust. According to multiple published reports, the president, through his businesses, derives income from foreign governments and their lobbyists, which also may violate the Constitution's prohibition against emoluments. The president reportedly intervened personally to block the FBI from moving its headquarters and thus opening up for commercial development a site just a few blocks from his downtown Washington hotel. The president reportedly paid little or no tax for many years, in part because of aggressive tax planning, and in part, perhaps, tax evasion. Finally, his foundation and inaugural committee are currently under criminal investigation. So I would open it up really to any one of you to comment on what I've had to say about the historical precedent that gave birth to this important law and the current facts as we know them. Professor Yin and then Mr. Rosenthal.
I would just say briefly that I completely agree with your point of the parallels of what happened almost 100 years ago that caused this law to be developed and the current time. I think the parallels really are very close.
Congressman, I would just add that the use of 6103F authority is use designed to further a legislative purpose, the checks and balance of our constitutional system. I do not believe the use by this committee to try to re-audit the president is what this committee would be pursuing. Of course, it's your purposes and goals that would need to be achieved. However, the conflicts that we're discussing, the conflicts with respect to the execution of the office of the president, the conflicts with respect to whether audits are being run correctly, the conflicts with respect to whether or not the president is running the country for his benefit or for ours. Those are all conflicts that are within the purview of the legislative branch to determine with respect to the executive branch. Remember, in my view, the legislative branch oversees the executive branch, not the other way around, and we have one president who runs it.
Well, it's not just your view, it's also explicit in the United States Constitution, so I obviously agree. One final kind of specific in the weeds point on this. The distinction between personal returns and business returns. In your view, would also looking at the business returns be necessary in order to address some of the questions that we have?
So, yes. Let me quote the current IRS commissioner, who during the campaign said, "To fully understand the financial status of Trump, one would need to see his returns for multiple years, the work papers for the individual returns, and the returns for numerous related entities." If you look to the president's own lawyers who wrote a letter describing whether his tax returns reflected Russian entanglements, they said that, and they looked at the 500 entities, business entities, that were listed on President Trump's financials and are linked, and the income flows through to the individuals. I don't think there is any question, but if you want to answer some of the questions that have been raised at this committee, you'd have to have business returns.
Thank you. And out of time, I yield back.
Thank you so much. Thank all of the members for your participation. The chair now recognized for 5 minutes, Mr. Arrington.
Thank you, Mr. Chairman, and Mr. Keyes, and thank you, witnesses. Mr. Keyes, you look like you might want to comment on that last question and dialogue.
Well, the only comment I was going to point out is that there clearly are ways in which the financial disclosure rules could be modified to make them much more useful and much more informative without getting tax returns. But this issue of whether or not the current statute is a consequence of what happened back in the 1920s, I think is misguided. It is more a function of what happened in the 70s. In fact, when Congress rewrote Section 6103 in 1976, it was because they were concerned that Richard Nixon and his White House were handing out tax return information all over the place. And that's why Congress, this committee, wrote as tight a provision as Section 6103 as it exists today. And contrary to what my friend Georgian suggested, my misunderstanding, I don't have a misunderstanding of the statute. I encourage all the members of the committee to actually read the statute. It is unequivocal in terms of what it says.
Are you trying to tell me that in the 1970s, there were actually petty, self-serving, politically motivated people in this line of business?
It's hard to believe, but yes, that's the correct.
And that's why we tightened up the restrictions so that we wouldn't open up people's tax returns to political abuse of power?
The difference between the 76 rules, which is basically what we have today, versus pre-76 was fundamental. It referred to tax returns prior to 76 as public property, public information. The 76 Act, which basically is what we have today, tightened those rules down immeasurably, and it's reflected in 6103A, which is the only provision of Section 6103 that contains a substantive penalty for failure to comply with it. The rest of 6103 is a bunch of procedural rules, and with all due respect to my friend Georgian, he's looking at 1920s legislative history to try and inform us as to what this provision means today. I strongly encourage every member of the committee to actually read the statute.
Mr. Keyes, I'm surprised that with a panel of experts, tax experts, experts on this issue, that when asked if they believed that the IRS was fulfilling its duty to execute on mandatory annual audits for the president, that there was great uncertainty. It seems like we've got a very distrustful panel, but I would give them the opportunity again if they believe, in fact, that those mandatory audits are going on. But before that, if they are going on, and I'm going to assume that the IRS is doing its job and auditing this president, would the issues like effective tax rates and whether the president is paying his taxes or if he's evading them, or sources of income loss and deduction, those things that Mr. Rosenthal mentioned, would those not be discovered in an audit? And if there were problems with that, would those not be flags, red flags, that would come up in such an audit?
Well,
Just
certainly,
yes or no?
certainly all of those things would be information which the IRS could get. And I guess I would say in response to the issue of whether or not people believe that the president and vice president are being adequately audited, I will say for me personally, and I would speak for everybody in this room, I don't think you want to have done to you what probably is being done in the form of the audits of the president and the vice president. I suspect they're pretty intense.
So nobody up here is against improving transparency and identifying information where it would present a better picture of potential conflict of interest. I think financial disclosure forms and ethics forms, and there are plenty of other ways that we can do this without opening up such abuse that occurred in the 70s, which then transpired into more restrictions to prevent that abuse of power. Mr. Rosenthal, do you have confidence in the American people's judgment when it comes to this issue of disclosure of people's tax returns, the president's in particular? Do you trust their judgment on this issue?
I've seen polls that more than 60% of the American public believe the president should disclose his tax returns. Those have been almost constant since the campaign.
Mr. Rosenthal, did you see the election return? Did you see the election results? Because this was an issue during the presidential election. If I recall, this was an issue in the primary. It was an issue in the general when candidate Hillary Clinton disclosed her tax returns. So the American people were well aware of this, and I've got a whole lot more confidence in the American people than they have in this body to conduct themselves in an objective and fair manner when it comes to these sorts of issues. I'm very concerned with giving this body politic more power to abuse not only this president, but potentially the American people. Mr. Chairman, I yield back.
Oh, I would just say I don't know what to make as a matter of policy based on an election. The American people may have expected the legislative branch to continue to oversee vigorously the executive branch and may have expected further oversight.
Thank you very much. The chair now recognizes for 5 minutes, Mr. Gomez.
Mr. Chairman, thank you so much. Thank you for having this important hearing. I find it interesting on a couple of things. First, on the question of, is it required by law? It's not required by law that a presidential candidate submit their taxes to reveal them. But as a matter of custom and practice, that's what's been done since the early 1970s. And it is oftentimes somebody who comes along and rips apart that custom that then the body politic, the legislative branch, or the public itself has to take action to codify that custom and practice. We do that all the time here in the House, where there was unwritten rules that were custom and practice, and then somebody breaks them. And then the House takes action to codify those. This is just another example of taking that step as part of H.R. 1 to take that step to require all presidential candidates and vice presidential candidates to reveal their tax returns. You had a good historical point where I was actually thinking the same thing regarding the two-term. A lot of things over time in our history of government were custom and practice. Then somebody came along and broke it, and then we passed a law to fix it. So on that issue, let's set that one aside. on the issue of excuses, first, the president, when he was a candidate, said his tax returns were under audit. He couldn't return them. Now the gentlemen on the other side of the aisle are saying that it's under investigation by the special counsel. Sooner or later, I'm going to hear that a dog has eaten his tax returns, and I don't even know if this president has a dog. So we hear one excuse after excuse. And our responsibility is to see if there is a reason to go after, a legitimate reason. Just to kind of clarify some of the rule and authority of this committee. Mr. Yin, you mentioned there's a discussion on post-1976 rule. What facts give you the understanding that we do have that authority and we continue to still have that authority today?
Thank you, Congressman Gomez. I completely agree that the 1976 Act was designed to strengthen taxpayer privacy. That was the overriding goal without any question. But it should be noted that in 1976, Congress specifically took away the ability of non-tax committees to submit information to the House or the Senate and to have a public release of it. They amended the statute to say that any submission could only take place while the full House and the full Senate are sitting in closed executive session. Importantly, even though they obviously had the ability to put the same condition on the tax committee submission, they did not. And my reading of that is that Congress wanted to keep at least one vehicle open to preserve its informing function relative to tax return information. If it had imposed the same restriction on the tax committees, then in effect Congress would have said, nobody ever has an opportunity to inform the public if it relates to tax return information. And I find that result completely inconceivable. And so I believe that the history of this provision, which was unchanged in 1976 relative to tax committees, prevails in explaining exactly what the authority of the committee is.
And just to reiterate, to really kind of focus in, why is Congress so committed to retaining that authority?
Well, I think Congressman Boyle said it very correctly, which is that one of the principal, if not the most important responsibility of Congress is to make sure that the laws are being faithfully executed by the agencies and by the high-ranking officials and so forth that are that serve the country. And so it's important then to have the ability to inquire about whether those laws are being faithfully executed, and to the extent the Congress were to find that there's been a violation, it certainly is the congressional responsibility to inform the public of that. That seems like a very foundational responsibility of Congress.
Yeah, that's the basis of our government, right? Checks and balances. And without that ability to do that, then we don't have a check on the executive branch.
Exactly right.
The chair is pleased to recognize Mr. Pasquale for 5 minutes, and I apologize for passing you over.
No problem, Mr. Chairman. Mr. Chairman, I want to enter to the record the articles, How a Simple Tax Rule Let Donald Trump Turn $916 Million Loss into a Plus. Second, Trump engaged in suspect tax schemes on the reaped riches from his father. Number 3, Trump Foundation will dissolve, accused of shocking pattern of illegality. I didn't mention those articles. Now I mention those articles. Put them in the record. My request. Thank you. Mr. Chairman, I must speak. It's going to take time for my questions. Thank you. About hypocrisy. Hypocrisy. So we want to protect the privacy of the president, and I would too, but we don't want to follow the law. When I said no one is above the law, I mean no one's above the tax law. And in this case, the tax law is 6103. It is the law of the land. When Democrats and Republicans feasted on scandal and bribery, that's the law of the land. So he is not above the President of the United States. President Trump is not above 6103. And it pertains to everybody in the executive branch of government, not just the President. Because Secretary Fall, who was the Secretary of the Interior at the time, was the one who put this scheme together. And we went after him back in 1923. Okay. That's what happened. So, Mr. Keyes, thank you for joining all of these great people like yourself. I've read your stuff. We don't agree on some things, and we do agree on some things. What do you know about that? So, Mr. Keyes, do you believe, this is a different part of the question, do you believe committee Republicans violated the law in 2014 when they released taxpayer information, over 50 taxpayers, and they found nothing? Do you believe they violated the law?
Absolutely.
Thank you very much, Mr. Keyes. Thank you for your honesty. That's what I expected. So let me have a question here for Mr. George Yen, Professor Yen. Some of this committee have claimed that releasing the tax returns of the president under 6103, that authority, to be a political abuse of power. By the way, we've sent numerous letters to Mr. Brady when he was the chairman of the committee saying, let's do this together so it is not partisan. Bull to what they're saying today. Professor Yen, you've written about this committee's use of 6103, this committee, to obtain and release the tax information to more than 50 taxpayers in 2014. That happened along partisan lines, Republicans voting to release the information, Democrats were opposed. Can you explain your thoughts on the committee's use of 6103 in 2014?
Congressman Pasquale, I'd be happy to. In that instance, the committee did release the tax return information of, by my count, 51 separate organizations, with almost half of them having multiple pieces of tax return information disclosed. And I looked very closely at that whole situation. 41 of the organizations had absolutely nothing to do with the specific committee investigation and allegations relative to Lois Lerner and the IRS and the purported discrimination by the agency against right-leaning exempt organizations. They had absolutely nothing to do, and so the release of those, the information for those 41 seemed to me to be a clear violation. For the other 10 organizations, which were all right-leaning exempt organizations, the committee's allegations with respect to that were that they weren't processed quickly enough. The allegations did not go to the substance of the actual applications themselves. And so it seemed to me that if the committee wanted to publish a letter indicating the objection as to how it viewed the IRS and Ms. Lerner's treatment, there was absolutely no reason to name the organizations and to reveal any tax return information. They could have made exactly the same point as the Treasury Inspector General had made just a few months earlier in bringing the matter up to the attention of the committee by referring to 10 right-leaning exempt organizations or 10 Tea Party-type organizations or whatever name would be appropriate to provide the general sense without necessarily naming and revealing any tax return information. So I concluded all 51 disclosures were a violation of the law.
Mr. Chairman, thank you for your courtesies and your indulgence. This is a very critical issue for the American people who are interested in the subject. We're not interested in getting someone. We're interested in following the law, period. That's it. Give us the chance to do that. Give us a chance. What am I saying? Give us a chance to follow the law. And that's what we're doing. And we will not stop. Thank you.
Thank you, Mr. Pasquale. The chair is now pleased to recognize Mr. Ferguson. Yes.
Thank
5 minutes.
Thank you, Mr. Chairman, and I would like to yield as much time as he may consume to my colleague, Mr. Rice.
Mr. Pasquale said that we need to follow the law, right? We need to follow the law. Mr. Thorndike, can you cite me statutory authority as the law that requires the president to disclose his tax returns?
There is no requirement that the president...
Mr. Yim?
Nothing in the law
Okay,
right now.
Thank you, Mr. Rosenthal.
None to my knowledge.
Mr. I can't read it, I'm sorry.
Bookbinder.
Bookbinder.
No current law, although there's a bill that you're discussing
Mr. Keys,
here.
what is the statutory requirement that
there is none?
There is none. So we are following the law. And you know, why would we want the president to be required to disclose his tax returns? I mean, it's been real clear from the testimony of all of the witnesses here that we want to check for conflicts. I mean, really, that is the primary reason, right? We want to see personal benefit or conflicts. So why hadn't we thought about that till now? Oh, wait, we have. Doesn't the president have to make disclosures, Mr. Thorndike, Dr. Thorndike?
In what sense? Disclosures of what?
Doesn't he have to make financial disclosures?
Yes, but that's not that's not necessarily what we're talking about, I don't think.
Well, I mean, the Ethics in Government Act of 1978 requires personal financial disclosure forms by the president and all members of Congress as well, right?
It's true, but if the president...
And it's very detailed about what we have to disclose. I mean, we have to disclose information. I'm a CPA. I'm a tax lawyer.
It's
we
true,
have to disclose a lot more information than you have to disclose on a tax return about ownership, about percentages, about, you know, in fact, Mrs. Moore was asking, she'd like to know more about the president's loans to Deutsche Bank. I just pulled up the president's form. It's 108 pages long. The loan to Deutsche Bank is listed right there. The rate, when the loan matures, the amount of the loan. Could you look at the president's tax return, Mr. Keys, and determine what the rate was on his Deutsche Bank loan?
I think it's probably unlikely.
Yeah, and would you even know he'd borrowed the money from Deutsche Bank if you were looking at his tax return?
It's unlikely. Probably the only way you'd know these things is by, and as has been pointed out by some of the other witnesses, is getting business returns. If Congress thought, you know, if the government thought that disclosing tax returns should be required, Mr. Rosenthal, could we not have required that in the Ethics Acts of 1976?
At the time, there were voluntary disclosures going on. It may not have been viewed as necessary. I don't
Could we have required that, Mr. Bookbinder? Yes or no?
Yes.
Yeah, of course we could.
Can change.
But we didn't think it was sufficiently important to require it. We don't think it's sufficiently important unless it's our political enemy. Mr. Pasquarel was talking about hypocrisy. I'll tell you, the Democrats are anything but hypocritical. They love to weaponize the IRS, a.k.a. Lois Lerner, and now going after the president's tax returns. I think that in the Stock Act, we recently reviewed this ethics disclosure, and we tightened it up, 2 or 3 years ago. So this is something that is not new. This is something that's been considered over and over again. It has been tightened more and more. And, you know, in our zeal, the zeal of my friends across the aisle to attack this president, to weaponize agencies of the federal government, including the FBI and the DOJ and now the IRS, to pursue him with any means possible, now they want to go after his tax returns. When it's not required, it's never been required. We could have required it any time we thought it was appropriate. We could have passed the law. There's a prospective bill put out there now that may be considered at some point, and hell, maybe it'll pass, but there is nothing that requires the president to disclose his tax returns. And to say that the president is not complying with the law is an abject falsehood. It is an abject falsehood. One more time, Mr. Keys, is the president required to disclose his tax returns?
No.
Thank you, Mr. Chairman. I yield back.
The chair is pleased now to recognize the gentleman from Texas, Mr. Doggett.
Thank you very, very much, Mr. Chairman. We today pursue two issues. One is how to address with new legislation a situation where a future president might decide to reverse himself or herself the way President Trump did and not make available tax returns as all recent candidates for president have done. And the second is to look at the basis and the process under a law that is almost a century old that gives the chairman of this committee the authority to review tax returns, and if this committee so decides that it is in the public interest for this committee to vote to send that information to the House where it can eventually be made a matter of public interest. Seeing the President's reversal, his entanglement with interest abroad and at home, seeing reports that he and his family may have benefited in excess of $1 billion from the tax bill that he forced through here without a single person from his administration coming to testify in favor of it or explain it. Seeing all that, I moved on 6 different occasions in this committee over the last 2 years to use 6103 to obtain the President's tax returns. And each time there were excuses and cover-up from our Republican colleagues as they obstructed and protected the President. Now, the President apparently had enough concern about this that he did have a review made of his tax returns. The review was made by the President's own lawyers, in fact, from a firm that proudly declares that it was the Russia Law Firm of the Year that made the review of his returns, noting not only that he had personal returns, but more than 500 separate entities that stretch from Azerbaijan to Panama. And they gave him a all clear, his personal law firm, of that. I suppose that is a kind of review, but it is not one that inspires public confidence. The Commissioner of the Internal Revenue Service, Charles Rettig, before he was appointed, said that, quote, for wealthy individuals, individual tax returns sometimes only provide a brief financial overview linked to numerous other conclusions and entities. To fully understand the financial status of Trump, one would likely need to see returns for multiple years, the work papers for the individual returns, and the returns for numerous related entities. Mr. Rosenthal, do you agree with that statement?
Yes, I do.
And while having a president with such a sprawling business empire may be unprecedented, we know there are others. Some have already announced as possibilities as independents or Democrats for the 2020 election. Every president, vice president, and candidate for the future, I think, should be held to the same standard that we would apply to President Trump. Mr. Bookbinder, do you believe that H.R. 1 should be strengthened to include a requirement that all candidates disclose their business entities?
Yes, I think recent events make clear that that is really important.
And Mr. Rosenthal, might such information inform how much weight is given to a given policy of the President of the United States?
Yes, those type of disclosures would inform Congress's weight and deference to executive actions.
We know that the President plays a central role in tax policy, that his Office of Management and Budget offers a review of tax regulations, that he lobbies for and influences and signs legislation, that the Treasury Department that he appoints plays a big role. With these multiple roles that the President plays on tax policy, is it essential, Mr. Rosenthal, that we have his returns to review the impact on those policies?
Yes, I believe the regulatory process and the efforts that the President and discretion the President has warrant the Congress and this committee understanding what financial interests he might yet have.
Thank you. And Professor Yin, an important point, while our focus in this committee is the tax system and the public confidence in that system and whether this president is using his office for personal gain, the responsibilities, when you talk about the legitimate purpose for using 6103, doesn't that extend to many other issues, such as his possible violation of the Emoluments Clause, his entanglement with Russians and Saudis and others who he may be doing business with or for, because this committee has a responsibility broader than just its own jurisdiction over the tax code?
Congressman Doggett, I believe you're right, and that's simply because Congress right now has delegated strictly, exclusively to the tax committees this ability to inform the public about tax return information. So I believe that the legitimate purpose for the Ways and Means Committee would extend to a constitutional responsibility of Congress and not limited to the legislative jurisdiction of the committee.
And just one final one, Mr. Chairman, and Professor Yin, is it also not true that this committee and should it decide to make these records public, has powers that even the special counsel, Mr. Mueller, does not have.
Yes, that's a very valid point, and that's, again, another issue down the road, which is that the special counsel can disclose tax return information only in limited circumstances, such as a judicial or administrative proceeding. If he were to issue a report, it's not clear whether tax return information that might be critical to his conclusion in the report could in fact be revealed to the public, even assuming the Attorney General were to allow the report to be revealed at all. So that is another issue.
Thank you, Mr. Chairman, and I just would ask unanimous consent to include in the record the testimony of Public Citizen concerning its support for the disclosure of presidential and vice presidential tax returns, and the important report of Americans for Tax Fairness, the case for Congress obtaining Trump's tax returns.
So ordered without
Thank you for your tolerance.
Thank you. Now it is my pleasure to recognize the gentleman from California, Mr. Panetta.
Thank you, Mr. Chairman. I appreciate this opportunity, and thank you for letting me sit in on this hearing. Appreciate that. Gentlemen, thank you very much for being here today, as well as your preparation for your testimony today, too. As you heard from one of my colleagues, and as you know well, there is no law requiring a taxpayer to turn over the tax returns to this committee, correct? Mr. Yin?
Referring to the president?
Yes.
There is no law that requires that. That's correct.
But there is a law saying that this committee can obtain those tax returns, correct?
That's correct.
Okay. And that's 6103 subdivision F subdivision 1, correct?
That's correct.
And it actually says that any taxpayer shall furnish the tax returns to the committee, correct?
It says the Treasury Secretary shall furnish the requested information to the committee.
Exactly. So that's not a should or a coulda or a woulda. It's a shall. It must if we ask for that, correct?
That's correct.
Okay, great. And Mr. Yin, I'm going to focus on you, gentlemen. Please excuse me, but I'm going to focus on Mr. Yin if that's okay. And your testimony, Mr. Yin. You basically talk about on page 2, you talk about, this is your formal written testimony, you talk about the situation where there would be a refusal to turn over these tax returns in this situation that we've been talking about, and that most likely you say that it would lead to the courts. It would be a potential judicial resolution, as you say, correct?
It might. It depends on how the Congress reacts to that refusal. Obviously, Congress could simply say, well, okay, that's too bad. Or Congress could try to enforce its request, and that might end up in court.
Understood. And if it went to a court, what is your, how do you think these courts would look at that situation? What would they use?
Well, again, as I indicated in the testimony, I think we're on uncharted territory because I don't think this specific issue has ever arisen before. At least I'm not familiar with it. But there is a little bit of law about enforcing congressional subpoenas, and this would be somewhat analogous to that. And the law generally says that Congress must act with a legitimate legislative purpose.
And in regards to the case law that talks about a legitimate purpose, can you go into a little bit more detail behind those words?
Yes, I'd be happy to. So the foundational case was an 1880 case, the Kilburn versus Thompson case, and that involved a situation where Congress was making an investigation relative to a bankruptcy, and there was a settlement, and there was a particular company that was affected by it, and the congressional inquiry essentially went to the nature of that. The party that was being subpoenaed refused, and so this eventually went to the Supreme Court. And the court found that it could not find any legislative purpose for this inquiry. The court said there's no legislation envisioned in this conflict that's arisen. And in fact, the court said we can't even imagine how there would be any legislation relative to it. It said essentially, if this is a conflict, it's a conflict for the courts. It's a conflict for the judicial branch to resolve, not the legislative branch to resolve. And so that, in that instance, the court concluded that the legislative inquiry was not going to be enforced.
Okay.
There are other examples, obviously, I can give you.
Please, in regards to any that have been enforced.
Yes, certainly. Well, so in 1927, there was another Supreme Court case, the McGrain versus Dougherty case. Dougherty, in this particular case, was the brother of the former Attorney General, Harry Dougherty. Harry Dougherty had been one of the principals allegedly involved in some of the Teapot Dome matters. And in this instance, Congress was seeking testimony and documents from the brother of Harry Dougherty to, again, complete the investigation of this. And the brother refused. So this also went to the Supreme Court. And in that case, the court made it very clear that this was an appropriate legislative purpose to investigate the possible wrongdoing in the executive branch, and therefore it did enforce that request.
Okay. And these are the types of cases you believe that courts will look at for precedents, correct?
Well, again, it's speculation on my part, but it would be, I would think, if I were a judge or the clerk for the judge, that would be certainly an area that I would direct the attention to.
Thank you. I yield back my time. Thank you again, Mr. Chairman.
Thank you. The chair now recognized for 5 minutes, Mr. Reed.
Thank you, Mr. Chairman. This has been actually a very insightful panel, and I appreciate the testimony of the witnesses. But as I venture down my questioning, I just want to make sure we're clear. I've heard from each one of the witnesses that there's a right to privacy issue here based on the historical review of the documents. From each of the testimony, does anyone disagree with an issue or a concern that is legitimate being raised on the rights of privacy of individuals, that's 6103, or this proposed law, that we need to take that into consideration? Does anyone disagree with that?
Well,
yeah, Mr.
One thing I would say in response to that, and it's something that no one on the committee has asked about yet, but I think it's an important piece of information. 6103 has never, ever been used to request taxpayer information by the Ways and Means Chairman, the Finance Committee Chairman, or the Chief of Staff of the Joint Committee that has been released publicly. Professor Yin referred to the Nixon situation. Nixon had agreed to let his return. When I was Chief of Staff of the Joint Committee in '85, we requested individual income tax returns in connection with our study of why wealthy Americans were giving up their citizenship. That return information was never released to the public. So we can debate whether or not the authority exists, but what is not in debate is it will be unprecedented if that authority is used to release taxpayer information.
And Mr. Yin, so do you agree that there's no
yes,
concern about
so
privacy?
I disagree with that response.
No, not with Mr. Just my question, because I had
Ms.
limited time. Are you concerned about the right of privacy that's being raised here? Do you think there is no right of privacy to anyone?
So I believe there's a balancing between the right of privacy of individuals and the right of the public to know. And it's up to the Congress to determine how to strike that proper balance.
How to strike that, right? And that's exactly what we're wrestling with. And so the issue I have, because when I heard you testify to, I think it was John Kerry's wife, Geraldine Ferraro's husband, who was concerned about their privacy, they didn't run for public office, right? They didn't venture down this public domain path that their husbands or spouses did, wives did. And so the question I have for you is that if you get a presidential return that shows the president having a relationship with Mrs. Jones down the street, Mrs. Jones' privacy right needs to be respected, correct? She has a privacy right that her information, that she happened to do business with an individual who happens to run for president unbeknownst to her 10, 20, 30 years, 10 years down the road, 5 years down the road. Her right needs to be respected in this conversation, correct? Does anybody disagree with that?
I agree.
You agree with that?
Her right should be respected.
Yeah, so the issue that I'm wrestling with here is there a better way to do this? Because, Mr. Bookbinder, you're very familiar with our financial disclosure statements, and you offered testimony that said, you know, what we can't find from this financial disclosure, if it's a $6 million deal or a $600 million deal, that's potentially a conflict of interest. But isn't that irrelevant? The fact on the financial disclosure, it discloses the relationship upon which the conflict arises. So if the financial disclosure shows that, regardless if it's $1 or $1 trillion, it's still a conflict that can be investigated, and that information's out there. Isn't that correct?
I think that is correct, but there are likely to be relationships that are going to be shown in the tax returns that are not shown in the financial disclosures. And certainly when privacy is incredibly important, but when somebody chooses to run for president, they give up lots of pieces of their right to privacy.
And so, Mr. Bookbinder, you just teed up exactly where I think maybe a wiser course for this subcommittee to pursue, is if there's a concern about the financial disclosure and the information that that president or that vice presidential candidate or any candidate who runs, that individual chooses to do that, isn't that the more appropriate vehicle for us to be considering legislation to say, look, if you're running for president, we want your own form under the financial disclosure information. We want you to fill out all of these issues, rather than run the risk of some Mrs. Jones's privacy being violated because someone wants to get a tax return. And I don't challenge Mr. Neal's integrity in regards to his authority to use 6103. He's a gentleman. I respect him. But I'm concerned about the next Ways and Means chairman or the next political battle that chooses to utilize this weapon that could potentially be abused by a future chairman or any chairman. And so shouldn't we focus our time on actually what could potentially bring members like me from the other side to say, let's amend the financial disclosure reforms, target the information to that form for that individual, and at the same time, we respect the privacy of individuals that had nothing to do with running for president or vice president. And I'll let you ponder that, and with that, I yield back.
The chair now recognizes for 5 minutes Mr. Kelly.
Thank you, Chairman. And again, thanks for holding the hearing. All of the panelists, thanks for coming in today. I want to go back to what Mr. Reed said, because I think, Mr. Bookbinder, would you clarify for me? You say, so when somebody runs for president, they give up their expectations of privacy? Is that what?
Well, I think anyone who runs for president expects to have a lot less privacy than most individuals.
So anybody that's a candidate for president or serves in the office is an American citizen. Is that correct?
Yes.
Okay. So are we saying if you reach a certain level, even though you're an American citizen, you're subject to greater scrutiny than anybody else? And then my next question would be, so at what point do people say, are you kidding me? Why would I ever run for any of these offices? It makes no sense. And I don't want you to even answer that because I know what the answer is. But I want to really be clear, and I want each of you to say, and I want an answer, not this may be, and I really appreciate your opinions, but you know what, may doesn't answer the question, because every time we ask you a question, well, this may be what happened, that may be what happened. Does the president and the vice president, do they not undergo the scrutiny of having their tax returns audited by the IRS? Mr. Thorndike, Dr. Thorndike. It's just a yes or no.
Yes.
Okay, they do. Professor Yin.
The Internal Revenue Manual does.
Well, the question is it a yes or no, Doctor? I appreciate that, but we're going to run out of time.
Well,
they're audited, are they not? Are not the president and the vice president audited? Their tax
the Internal Revenue Manual does require it, whether they in fact.
Okay, so I know you don't sit on it, so you can't be sure, but you know what the answer is. Mr. Rosenthal.
I have the same response.
You don't know either. Okay, Mr. Bookbinder.
I believe so, but I don't think it addresses all the issues.
Okay, Mr. Keyes.
Yes.
Okay, thank you. I'm glad we had experts here that could maybe know but couldn't really know. I just want to be clear on this. Listen, this would not be taking place if it were not about a duly elected president by the name of Donald Trump sitting in that office. This is an incredible overreach. This is an oversight committee. Our very role is to be the watchdogs to make sure that American citizens are protected. Now, if I were to go home to my hometown and walk up to somebody and said, I don't know that you realize it, but you know what? This 6103 is something right now that we really have to look at. And they're going to look at me like, I have absolutely no idea what you're talking about. And I would say in too many cases, we have absolutely no idea what we're talking about or what we're leading to. This, I said earlier, is a Pandora's box. You take the lid off this and you make anybody subject to this type of scrutiny. And it's hard for me to believe that since the mid-'70s, when we had the Watergate fiasco, that the changes to the IRS then, especially what happened under President Nixon, that we're saying today that this many years later, that we're just not sure that the IRS really knows how to do their job. I can remember not too many years ago, Mr. Reed, you sat here with me whenever we talked about Lois Lerner. And we questioned whether we thought the IRS was doing the right job of what was happening and the weaponizing of the IRS. And we were told, listen, are you telling us you don't believe the IRS knows what they're doing? Now, that was not done by our side of the aisle, by the way. It was the other side of the aisle that said, you can't possibly question the integrity of the IRS. And I do not question their integrity. Look, if there's better ways to do things, I think Mr. Reed hit on so many of them. This isn't the financial disclosures. If there's loopholes, if it's too wide, why not narrow it down? And one of the members said, this is not lazy legislation, what we're doing. Well, if it's not lazy legislation, I guess we can find some other term for it. It sure as heck is not doing our job as legislators. If there is some confusion, then we need to straighten it out. There are better ways to do it. I understand that. And as far as the trust and the faith the American people have, each one of us got elected for this very purpose, to protect their freedoms and liberties and their privacy. It's not to go after a political person that we just don't care for. Mr. Keyes, am I missing something here tonight? I mean, well, you answered things pretty explicitly. And I know you all have this great deal of background. But when you can't say you know for sure that the IRS knows how to do an audit, or if they're doing the audit, that's troubling to me. What else would you do? What else could we do to make this process better?
Well, I actually think what Mr. Bookbinder's talked about is a more productive route of identifying the kind of information that you really want here, which is a more vigorous financial disclosure for people running for president. And you can steer clear of having to delve into releasing individual tax returns, which has never, ever been done under Section 6103. And it's not a route that I think you should think about going down unless you're very, very careful. And frankly, I think if there's other ways to get the information, it's much better to go in that direction.
Okay. Dr. Yin, you had something to say.
I'd just like to correct the record on that, because Mr. Keyes has made the statement twice. He seems to have forgotten that both in 2014 and in 2015, 2014 in the House Ways and Means Committee, 2015 in the Senate Finance Committee, yes, there was the use of exactly the authority we're talking about now, combined with a public disclosure in each instance.
That was during a criminal investigation, is that right?
It was.
Okay, it was. Thank you. Listen, I wish we had more time. I would really love that. This could go on for a long time. But I know I share the same feelings as the chairman. Thank you so much for giving us your time and your expertise and weighing in on this. Just to make sure we leave this room today, we are the Oversight Committee. Our main role is to protect the privacy and the rights of every individual American citizen, of which our president happens to be.
No, I would just add one thing. I agree with what George just said. What I would say is it's never been legally used. George and I both agree that what was done in 2014 and 15 was inconsistent with 6103. Yeah. This committee has never legally released an individual tax return under the authority of Section 6103.
It sounds like you and George get together a lot and discuss this, so thank you so much for your time.
Let me just say to the ranking member, my friend, yes, Mr. Kelly, it is my strong belief that the American people have a right to know. We live in a democratic society. We should know people running for office, the office of president and vice president, how they earn their money and what conflicts they have. So the hearings, this is not the end. This is just the beginning. I want to thank each member of the panel for your participation, for your contribution. Please be advised that members have 2 weeks to submit written questions to be answered later in writing. Those questions and your answer will be made part of the formal hearing record. With that, the subcommittee on oversight stand adjourned. And thank you again.
Absolutely. Thank you. Thanks for having us in. Absolutely. Thank you.
Last time was a 2-day pass.